Janelle, are we ready to rock? Okay. Good evening, everyone. I'm Mayor Lawrence Rael, and I'm calling the Monday, December 1st, 2025 special meeting to order. The time is approximately 6:01. Thank you all for being here this evening. This meeting is streamed on the village website. The public can also participate via Zoom. Instructions and overall public participation guidance is listed on the website and on page 4 of the meeting packet. Now we'll turn it over to our clerk to further provide information regarding the meeting.
Thank you, Mayor. The Village of Los Ranchos is providing the ability for the public to participate in hybrid meetings. As with any application, digital service, or software, the opportunity for failure can occur. Therefore, the village is not responsible for the inability to connect to the meeting, either by the Zoom meeting link or viewing via live stream. The meeting is being recorded and will be available online after the meeting on the village website. One caveat to that, Mayor, is we're having a problem with the Zoom link right now, but folks can still watch via our website on the Board of Trustee page.
Okay, thank you very much. Madam Clerk, would you please call the roll?
Thank you, Mayor. Trustee Benavides?
Here.
Trustee Kiefer?
Here.
Trustee Ranovich?
Here.
Trustee Rynell?
Here.
Mayor, we have a quorum.
Very good. Would you all please stand and join me with the Pledge of Allegiance? I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all. Now, item number 4, approval of the agenda. Do we have a motion to approve the agenda?
Yeah, sure. Motion to approve the agenda.
It's been moved. Do we have a second?
I'll second it.
It's moved and second. Any changes to the agenda? Any discussion regarding the agenda? Seeing none, all those in favor of the agenda signify by saying aye.
Aye.
All opposed, same sign. The agenda is approved. We are now on item 5. New business. Ordinance number 305, an ordinance pursuant to Chapter 11.1.7 of the codification ordinances pertaining to compensation of the judge of the municipal court. We are asking tonight's action is approval to publish and advertise the ordinance. Mr. Chappell.
The Mayor, are there any witnesses that need to be sworn? Are there any public comments on these ordinances?
Yes, sir. We have one individual who'd like to speak on this item. Mr. Montoya?
Oh, anyone is going to speak on any of these items, if you would stand, raise your right hand. Do you swear to tell the whole truth and nothing but the truth under penalty of perjury?
All right, on this motion or on this matter, Madam Clerk, is there anyone signed up on this particular ordinance?
Let's turn it over to Attorney Chappell for the preview, and then we'll call up the individuals.
Okay, Mr. Chappell.
The Mayor and Board of Trustees, it appeared that the compensation for the municipal judge had not been changed since, I believe, 1985, and they thought that the compensation level should be changed. Current compensation is $50 per session. That could be any time the court appears. It could be one hearing. It could be 6 hearings or whatever on a single day. So I was asked to draft this ordinance to change the compensation level. The compensation level selected in this ordinance by the village is $150 per session. It still includes the same reimbursement of expenses and court expenses as was included in the prior ordinance. So the only real change is from $50 to $150 per session.
Okay. Just as a comment, I would say that, as you all know, the current rules are that if you're a sitting elected official, you cannot vote on an increase. It has to take effect, if you will, at the next election for those. And so since we just had an election, before the judge takes office in January. And that's why we thought we put it on this special session. It's just really just for advertising and publication for tonight. And then we'll have a decision on the 16th of December.
Yeah, Mayor, even though she doesn't vote on this,
That's right.
once she starts the term of office, it can no longer be changed. So
Exactly.
it has to be done this month.
And I don't know about you all, but a cup of coffee is not quite the $3 that it used to be back in the day. And so, exactly. So with that being said, do we have anybody else signed up?
Mr. David Montoya, please approach the podium, state your name and address for the record. You have 2 minutes.
2? So we got 3. David Montoya, 8831 4th Street. I'm all for it. I'd like to see this come into effect, and I'd also like to see a compensation package change for all our trustees and our mayor. I've got an idea that what we pay our administrator maybe could be divided up between the mayor and our trustees. So, and that could be, that would be kind of close to what we could, we have these high expectations here in the village. We sit in a place that's in the middle of the greatest municipality in New Mexico. We're right here in the middle of Albuquerque. They're our neighbors. They have 2 giant arteries that connect the west side to connect the second largest city at Rio Rancho, and here we are. And I'd like to see that our trustees are involved in Mr. COG and MRGCD, the city-county meetings, the city meetings. We expect a lot of our trustees. I really appreciate what you do here. I'm not doing it, and I do appreciate it. And I'd like to see that that put this on the agenda so that we can get a vote and get our people compensated and get a voice. I was personally at a meeting at MRGCD recently where 2 of our trustees spoke and our mayor called in. It was, people paid attention, and we can have our voice heard. But I don't want to take any more time than my 2 minutes. Thank you so much. Please take this up. Thank you.
Thank you, Mr. Montoya. With that, that concludes public comment on this item of business.
All right, thank you very much. Any discussion from the trustees? Trustee Ranovich.
Mayor, trustees, I would like to propose that trustees and the mayor get another round of raises, compensation in the future. And we may be able to vote on it. Well, some of us couldn't vote on it between now and the next term, but it's really important. And I think the thing that bothers me the most about this small compensation that especially the trustees get, but also the mayor, is that it doesn't allow for people other than either somewhat wealthy or retired people or close to retirement people like myself to run and hold that office. And we really need to allow more people within the village to hold political offices and hold elected positions. And the only way to do that really is to compensate them for the time off that they need to deal with it. So I would fully support that for the next coming year for the trustees to consider, or even at our next meeting in 2 weeks.
Thank you very much. We should probably have a motion to put this item on the, for discussion. So we need a motion to approve the publication of the ordinance.
I'll make a motion to approve the publication of ordinance.
Do we have a second?
And I'll second it.
Okay. Now, I would just say to you, to your comments, look, I think that the old adage, you get what you pay for. No offense to any of us here, But, you know, I do think that, that there are folks, obviously, that would love to be able to maybe join us up here or do some work on behalf of the village in elected capacity. But to your point, the compensation and the time, you all know how much time you all spend doing constituent work and doing meetings and additional meetings. I know I spend a lot of time. But yeah, I think that that's certainly something we should have a conversation about in the future. Any other comments from any of the trustees? All right, no other comments. All those in favor of the motion to publish ordinance 305 signify by saying aye.
Aye.
All opposed, same sign. Motion carries. We'll move on to ordinance 306. Ordinance 306 is a TA 25-02 requested by the Village of Los Ranchos de Albuquerque to amend the text of 9.2.14 Village Center Zone, 9.2.2 Planning and Zoning Commission, 9.2.3 Definitions, and 9.2.5 Establishment and Interpretation of Zones and Character Areas to remove unused terms, modify existing formatting for consistency, and establish additional development standards, as well as create a new zoning design 9.2.14.5 core commercial zone with all applicable zoning requirements and regulations. Tonight, we're asking for approval to publish and advertise this ordinance, and I'll turn it over to Ms. Schultz to explain.
Thank you, Mayor and trustee members. Ordinance 306 proposes to create a new zone in the code called Core Commercial. This is a sister piece of legislation to Ordinance 307, which seeks to change the zoning map, which I'll show you here in a moment. Once we change the zoning map and officially label parcels as core commercial, we then need regulations to go with them, and that's what Ordinance 306 does. This ordinance started before my time here, but my understanding is that there was a citizens advisory committee that talked about development along 4th Street, what was appropriate, what wasn't, and how zoning should perhaps change to better reflect the values and desired future for the corridor. As a result of those community meetings, the Village of Los Ranchos, as the applicant, put together a proposal to create the core commercial zoning district. What you have before you tonight is all the text for that new zoning district. So it regulates the uses that can be done in the core commercial zone, the height of the buildings, the parking requirements, etc. Before I go any further, let me just pull up a map for some context. That way we are all on the same page.
And Madam Clerk, while she's pulling up the map here, do we have anyone signed up to speak on this matter?
Mayor, yes.
Okay, great. Let's get your map done, and then we'll go to a public comment.
Trustees, what you see before you is the map referenced in agenda item 307, or I'm sorry, ordinance 307, but it's applicable to the conversation in 306, so I'm going to go over it quickly. The yellow bounded area contains all the parcels that will be rezoned. The purple parcels that you see are zoned VC today. Those will go to the newly created CC zone district. And in the kind of southeast corner here, this yellowish, greenish color of parcels are the existing VC project area parcels. Those will remain VC. So the core commercial standards that you're considering as a part of Ordinance 306 will be applicable to all of these purple parcels here. With that, I will stand for any questions.
Before we go to questions, Madam Clerk, when you call those individuals that have signed up to speak.
Thank you, Mayor. Our first individual is Mr. Vincent Sanchez. If you would, please approach the podium, state your name and address for the record, and you have 2 minutes.
My name is Vincent Sanchez, 6802 Rio Grande. I wanted to address something that from the last meeting, I felt that my point wasn't particularly clear. Attorney Chappell made it obvious to me. He wanted to attach the build to line to plats that would seek to be sent to like external agencies. But when I read the build to line definition, it seems to me that it was intended to be an internal usage and not to be used on plats for submissions to other agencies. It was more to define the conversation within the planning process. I'll read the definition. A build to line drawn on a plat or site plan or plot plan indicating a plane in which structures must be constructed when such lines are approved by the board if different from setbacks established in this chapter. The definition itself says approved by. To me, this is referencing a unique condition compared to the standard setback. Further, the if different from makes build to line unique from the standard, requiring an approval by a board which points to and applies to a variance, also before the fact. This definition, this is defining an area that has not been proposed or allowed yet. It's the bridge between the standard application and the non-standard request. The build to line, I believe, was supposed to define the happenings before the request. If there was something to add to kind of streamline what would be in the code, the residential setback reads, and I'll be real quick on this, the minimum front setback shall be 20 feet. The minimum side setback shall be 10 feet, and the minimum rear setback shall be 15 feet. For any property bounded by an irrigation ditch or drain, the minimum setback of the ditch shall be 25 feet. And this is where one can replace the other. The commercial code is far simpler, or far more clear, I should say, not simpler. For any property adjoining an MRGCD maintained irrigation ditch or drain, the minimum setback along the ditch
The
or
speaker's
drain
time has expired.
shall be 25 feet from the nearest bank edge of the ditch or property line, whichever is greater. To me, this is a very concise and clear wording for the commercial and could be supplemented for all of them. And that's it.
Okay.
Thank you. Mr. Ron Chavez? Yes, sir. Please state your name and address for the record, and you have 2 minutes.
Ron Chavez, 428 Chavez. Totally opposed to any of the Core 1 C1 being applied to Lot 41F2, 41F1A, 41F-1B, Lot 1A, 1B, and 2. Till we discuss the zone map amendment comes next, which might apply to establishing the old C1 zoning to those properties that I just described to you. That's about it.
Okay.
Thank you.
Thank you.
Thank you. Mr. Randy Gallegos, if you would please approach the podium, state your name and address for the record, and you have 2 minutes.
Thank you. My name is Randy Gallegos. I'm at 501 Sandia View Northwest. I also have my family's property at 502 Chavez Northwest, which is in this proposal. And like my Ron has asked if we could do what he suggested. Thank you.
Thank you, sir. Mr. Stephen Chavez?
Stephen Chavez, 432 Chavez Road. As the two before me were saying, hopefully you guys are interested in introducing an amendment to keep those properties out of the core commercial and establishing C1 zoning for those. Those are the only residential properties that are in that map amendment. So it does kind of limit to what you can build on your property. It's for any type of residential. I believe it's only mixed use, with the bottom floor being commercial and upper floors being residential, which kind of limits any of us being able to do anything with our property. I know housing is a big concern to most of you in here, so being able to amend it to C1, at least that still leaves townhomes. And then also I look forward to speaking with you guys in the future about other amendments to C1 to allow different type of developments that, you know, an individual could maybe pursue in the future to offer housing, something that looks nice for the village. It just seems like this for our properties, it's a little rough, especially when that bottom floor has to be commercial and you have to build 3 stories up above that. It almost only allows developers to build on that type of zoning. So, thank you.
Thank you. With that, Mayor, that concludes public comment on this item of business.
Just for the public and especially for those who spoke this evening, tonight's action is to publish and advertise the ordinance so that community members can get an opportunity, other members that may not have seen the ordinance, if you will, to come before the trustees and this commission or this board on the 16th. Is that right, Madam Clerk? Is that when our next?
Yes, Mayor, we will hear these items again on the 16th at a public hearing that evening for intent to adopt should the governing body choose.
Okay, thank you very much. We need a motion to approve for the publication of ordinance 306. Do we have a motion?
I will make a motion to approve ordinance 306 for publication.
Do we have a second?
I'll second it.
It's been moved in second. Now we're open for discussion. Members of the board, Trustee Benavides.
Yes, in regards to the residents that spoke during public comment for this particular agenda item, basically they have property that's just along Chavez, that's just south of well, we used to call it Northdale, but now we call it Los Ranchos Villas, right? And, you know, there's a barber shop there, and there's a Celine Cookies, and so they live behind that. And so I'm not sure how much we can do today, but I'm going to ask you what we can do. But I understand their predicament. And I also understand what they want is consistent with our master plan, which is the ability to densify the residences. So if you leave it as core commercial, the only option they have to build a resident is to have, I think, like 50% or the ground level be commercial, something like that. So that's very constraining to them. And if you want to see members of the Chavez family stay along Chavez, I think it's a good idea to help them out, and instead of having them as core commercial, have it as C1, which gives them that option. And I think that's what they're after. So I guess I would like to ask Shanna what sort of amendments we can make. I know this is just to publish. Are you, if I understand what I think I heard the mayor say, we need to wait until it actually comes to us for approval before we make amendments?
Mayor Royale, Trustee Benavides, my understanding, yes, is that the intent of this meeting and the vote tonight is only to publish, that if the board wishes to make substantive amendments to the text, that will have to wait until you are on the discussion of the actual bill, which won't be until the meeting at the 16th.
Can we even change the map and take it out of the core commercial, and which would leave it back at VC, but then we know it will need to be changed, right?
Mayor Royale, Trustee Benavides, the option that would be on the table for the board on the 16th is to either leave those properties in the zone map amendment, which would effectively change them to CC if the board chooses to adopt the ordinance, or to amend the map as it's proposed to take them out of the consideration for the change to CC. What the board could not do as a part of this action is change those parcels to C1. C1 was not on the table for discussion as a part of any of this amendment procedure. So I think the best option to respond to these residents would be to change the map to remove them, and then they could come in for a zone map amendment for their own properties at a future date to request the zoning district that they want.
So can we do that today?
Mayor Royale, Trustee Benavides, that would need to happen at the 16th. That's when you could make a motion to amend the map to remove those tracks.
Okay, and then, but then to get it to change, put in an agenda item to get it changed to C1, that would have to happen, the soonest that could happen, it would be January. Is that what you're telling me?
Mayor Royale, Trustee Benavides, I think that's a little complicated. If those get removed from this action, I don't know if the Village of Los Ranchos, I might look to Bill here, could propose a zone map amendment action on the behalf of just 5 property owners. The zone map amendment action before you tonight is kind of a large swath of properties. It's a legislative action. I worry a little bit about the village pursuing a zone map amendment for just a small number of properties and a small number of property owners. Legally, I'm not sure that we can do that, but I would invite Mr. Chappell to chime in on that question.
Mayor and Trustee Benavides, the more direct way to do that would be for the property owner to file an application for a zone change, and then it could be considered in full. I think if we started trying to accept things out and change zone to C1, we would have a lot of procedural problems, publication problems, and that sort of thing. But it definitely can be changed to exempt it out of the change from VC to CC.
Okay, you're saying it can, say the last thing you said, it definitely can be what?
You can do an amendment which would take that piece of property out of the CC zone and leave it in the VC zone.
Yeah, on the
But you
16th.
can't change it to C1 in this process.
Okay. I do have other comments, but I would like to hear what the other trustees, what their opinion is on this particular topic.
Okay. Trustees, any other comments on this issue? Trustee Kiefer.
Thank you, Mayor. No, I'm with you, Trustee Benavides. I think that we need to, if the property owners are coming, and I guess my question is, Shannon, have you had a chance to look at from what I understand from the Chavez family is these properties were originally C1, and then they got turned into VC.
That's right.
And now we're trying to do CC. And it sounds like we haven't listened to the concerns of them. How did this happen that they even changed from C1 to VC? Do we know?
Mayor Rael, Trustee Kiefer, I had not had any conversations with the Chavezes, so I'm not privy to the conversations that you had with them. This is the first time that I'm hearing this issue.
Okay, but we don't have the history of what has happened with their properties.
Mayor Rael, Trustee Kiefer, I can maybe track down that history if there are good paper records on it, but I do not have that in front of me tonight for sure.
That history predates George and I being on the board. And I can tell you that I think the VC ordinance was approved by P&Z, I believe in 2018. So there's probably a map that went with it at that time.
Okay. Okay, thank you very much. Anything else, Trustee Kiefer?
Not on this particular topic.
Okay. I think Trustee Ranovich?
Did you got one? Oh, thank
Okay,
you.
Trustee Renow?
I would certainly agree with what's been stated here. It's been just turned around, manipulated a number of times. I think we need to get it straight. I think we need to support the residents and clarify for all, what is or what is not going to be included in C1 versus the CC. I think it's an opportunity for us to do that, and I would certainly ask that we consider it at the December 16th meeting.
Okay. Trustee Ranovich?
I have one more question or thought, and this is probably both for Bill and Shanna.
I wasn't done with my comments, but I was just.
No, I'm just,
Okay.
this is specifically to what we're all talking about. Shanna, is there a way to, within the language of the existing ordinance, to provide some sort of overlay for those sites, the Sandia Vista sites and the sites along Chavez Road, that would offer those property owners some flexibility so that they could keep that site either residential, or if they add on or change it in a major way, maybe, a percentage of the construction that it would conform to the village center. Would that be something that would be an easier way to modify what we're looking at in December that would allow just more flexibility for them as property owners, considering that they're the only single-family residences there?
Mayor Rael, Trustee Radnovich, I'm going to look at Mr. Chappell here to help me answer the question of As a part of what's on the table today, can we create a small mapped area of zoning rules only applicable to 5 or 6 properties? I'm not sure if procedurally we can do that. The creation of the CC zone district rules was treated as a legislative matter, and so I'm not sure procedurally if we can create new rules for a very small number of properties within that.
Mayor and Trustee Radnovich, an interesting question, but it seems to me like what you're proposing is kind of a special use overlay zone of some kind.
Exactly.
I don't believe that it is appropriate at this point to start carving out pieces of the CC zone and start focusing on specific properties, which would be a quasi judicial hearing, to create exceptions in the core commercial zone. If you want to amend the core commercial zone once it's in place, you can always amend it as to include different qualifications for different criteria for different areas. But this has been through 6 public hearings without that being there, and I think at this point it could, I don't know who would object, but could raise many objections that the process was not right because we've handled it as a legislative hearing as opposed to a quasi-judicial one.
We already have I'll call it quasi overlay for those parcels that are in the green. If you could pull up that map again, the green area, including those that haven't been built on. So there's already something there that there's already something in this code that we're talking about advertising that would that does set aside something, other parcels.
Mayor and Trustee Radnovich, the area that is in green is existing VC zone, and it remains VC zone. It is not being changed, and one of the reasons is because of the process we've been through. And so to the extent possible, the green area has been left alone with no changes, and the purple area has been pulled out of the VC zone. So that's not a special overlay or whatever, that's the existing village center zone we've had from the beginning.
But it is, I see, it's the yellow line shows the area of proposed zoning changes.
Yeah, and the reason it has to be in that yellow line for the change is because you have to do that to extract it out of the VC zone. So it is affected by extracting out the purple from the green. Because when you started, it was all green.
Okay.
Mayor, may I ask a question of Attorney Chappell?
Sure, if it's on this particular, related to this question? Go ahead, Ken.
Mr. Chappell, so because this is a item to advertise and publish, I guess my question is, doesn't that allow it to then be advertised and published? Because I guess my thought is, wouldn't we want to make any type of changes, suggestions to what we're going to advertise and publish so that the public is more informed on what those changes would be? So wouldn't now be a good time to extrapolate that particular properties? It then gives notice to anybody else during that advertisement and publish of what those changes would be, the ability to object, and then the ability for it to be heard December 16th.
I did not establish the procedure for this in terms of the way it was advertised just for publication. Typically, I would agree with you that if the more final version that you can get for the final hearing on the 16th, the better off you would be, but then trying to make changes to what was published.
But if we're approving now what's being advertised and published, can't we make those suggestions and changes now?
I think legally you can do so. I just don't know how it was published that would have perhaps precluded that. But I think, from the legal perspective, publication perspective, if you're going to make a change, from my side, it's better to do it today than on the 16th.
I would offer one more comment.
Hang on, but let's get to this point, because I think this is important. What we're proposing is a title, what was published was the title of the ordinance that talks about all the modifications. And that was what was considered by P&Z for several meetings. And the conversation today was to publish that so as we can give everyone in the community who is impacted by this, especially property owners who have property within that area. My only concern, and not that I'm an attorney here because I would defer to Mr. Chappell's expertise, however, it does concern me that if we start making amendments and changes now to the advertised piece, now we've confused folks in the community as to what is it you're actually advertising. And so the challenge that we have, and the reason it's sort of happened in this way for us as a board, is, two of our P&Z members are going to be taking 2 seats in this board in January. Normally, we could have said, let's advertise today, we'll have a hearing on the 16th and do what you're proposing to do, and then maybe defer it till January and then vote on that. But, once January comes around, we don't have, we have 2, obviously, trust, or 2 board members will have to recuse themselves. But all that being said, I'm just concerned that I think the purpose of this meeting is to do what we're doing now, is to bring these issues out to the forefront and ensure that the community and those who are listening can hear that there are some changes. And let me ask this one question to Mr. Chappell, or to even to Shanna. It seems to me that the actions tonight, aside from publicizing this ordinance and getting comments like we did, is that the only actions we can take is either to accept the map as it was proposed and or make changes to the actual map and to the, if you will, the requirements of each of the properties. And then if we want to come back at a future meeting to change that zone code or the zoning, if you will, of those properties, that's a separate action. Is that correct?
Mayor, if this ordinance is approved as it is, in order to make changes, you would have to come back in a separate action to do that.
Right.
And I followed it that far. The way the publication statute is worded, I think we've had some discussions on this. You could advertise it one time, 2 weeks ahead of time, let it come in, and you could actually vote on it at that particular time. In order to give more public input, we typically do it in a first reading and a second reading and so forth. And this is, and I don't recall how much of this has been discussed at prior Board of Trustees meeting. I've heard this over and over again, but primarily planning and zoning. So I think from a legal perspective, you can do it either way. And so that's the reason I said I'm not setting the procedure for how this process works, because I think either way is perfectly okay under the statutes related to publication.
Okay. Well, having said that, then, if it's the will of this board to want to make some of these changes and to have them incorporated into the document, what I don't know, and I would defer to the clerk, is how do we advertise a document that has now been changed and still meet the requirements of the rules? But maybe there is precedent for this and I'm not aware of.
So Mayor and trustees, the way the publication, should the board choose to approve advertisement, it will be advertised as the ordinance number with what's currently on your agenda. The entire ordinance will not be published, just the summary of the ordinance proposed. So we'll have 2 weeks until the 16th to hear it.
So in essence, if there is any substantive changes, those would be only available for the public just in terms of the discussion at this meeting. But we could not, any of those changes would have to occur when the ordinance is actually up for approval.
We can advertise any changes that you make tonight, should you choose, and post those on the website.
Okay.
And make sure that the public is very well aware of what occurred tonight. And then on the meeting on the 16th, should you choose to adopt, then we would have the most current version of what the board approves, and then that would be published as approved and adopted.
All right, so I think the point, I think, for clarification, is the title remains the same. The only thing we've got to do, if you all want to do some changes, is make sure we publicize those changes so that the full record is available for the public on the 16th. Is that
And
correct?
Mayor, yeah, one missing piece is that the ordinance that is being published, even though you just published the title and the summary, must be available for public inspection here at the village. So anybody interested can come in and look at it and see that final version before it shows up on the 16th.
Okay. All right, if that's the will of the board, then we will then move. First, I know that Trustee Benavides started this conversation. If you all don't mind, I'll go back to him. Trustee Benavides.
Yeah, I mean, it sounds like this is a two-step process, right? The first step is to take it out of core commercial, which it appears that all we're going to do is redraw the yellow line, which means it stays at VC. And then there has to be an application for zoning change from VC to C1 for those property owners, right?
That's correct.
But today, we can redraw the yellow line, and I guess you need to have it published and advertised for 2 weeks prior to approval. Is that the requirement?
Madam Clerk?
Mayor and trustees, yes, that's correct. That's by a Village of Los Ranchos ordinance and state statute.
Which means you'd have to have everything together by tomorrow, right?
That is correct.
A new map. Is it a problem to redraw the yellow line?
Mayor Rael, Trustee Benavides, as long as I can get the specific information on which parcels, I will need parcel numbers and ideally UPC codes for each of those. I just want to make sure I draw the map right. Yes, I could get Danielle a map tomorrow.
Okay, so I can propose an amendment, is that right?
Okay, propose an amendment?
I don't have all the property descriptions in front of me. Oh, okay. So I would like to.
Mayor Rael, Trustee Benavides, I'm sorry to interrupt. This is about the zone map amendment, which is item C on the agenda.
Would you rather wait till we do that?
Yeah, we're still on item B, which is about the text of the core commercial zone, so save that for item C.
I can do that.
Okay.
I think, yeah, that makes sense.
Thanks for the correction.
So let me finish with my other
Okay,
comments.
go ahead.
And this should go fast because I did talk to Shanna earlier. But on page 11, I thought the text was very confusing. This is under core commercial zone. Item B, purposes and intent, the last couple of sentences there says, I'll just read it, just so you can see how confusing it is. Inclusion in the village center zone of the area now to be encompassed by the core commercial zone was deemed to be an error or a mistake as a potential development of the area within the core commercial zone due to parcel configuration, size, potential developments, parcels, and other factors. It is now deemed appropriate to rezone the area's core commercial zone to be more closely aligned with the C1 zone, which was previously a part. Okay, that last sentence is understandable, but the previous sentence, starting with the inclusion in the village center zone, I think there's got to be a better way to word that.
Mayor Rael, Trustee Benavides, in rereading this intent paragraph, I actually just don't think that those last two sentences are necessary at all. You're supposed to be describing what is the CC zone district, what is it supposed to look like, what is it supposed to feel like, and those last two sentences are about why we want to rezone things to core commercial. It doesn't fit for me. And so if I agree it's confusing, it needs to either change or be deleted. I would suggest we just delete it, and I would be happy to propose an amendment to do that at the next hearing.
That would be great, yeah, and I would be happy with trusting you to do the right thing there.
Okay.
Let's see, more confusing text on page 19. let's see, this is under VC Village Center Zone. It looks like this is mostly about this ordinance is mostly about the core commercial, but there are some changes made in the VC ordinance as well, right?
Mayor Rael, trustee Benavides, yes, it's
Okay.
largely kind of cleanup action, but yes.
And so in the third paragraph, that first sentence with the copy that I'm looking at has a bunch of red lines, but even if it was cleaned up, I'll attempt to read it. The Village Center project area, as shown on the current zone map, is now all the land, I'm sorry, it's hard to read, and property included in the Village Center zone. All other land previously in the Village Center zone is now included in the core commercial zone. But that first sentence that I read, I thought that could be a lot clearer as well.
Mayor Rael, trustee Benavides, I have similar feelings to this sentence, that this is describing why we changed the map. That is not what this purpose and intent section should be about. It should be describing what the Village Center zone is trying to accomplish, look like, feel like. And so I will come prepared with some smart changes to that section as well at the next hearing. Okay,
And just, I'd like to make a few comments for the public, because I know the VC code, and I'm not going to have a problem with this, but I think the VC code is problematic to a lot of people, and this is what I would say. The VC code basically set the stage for the development agreement way back when. And I do worry that, and I look for any reason why there would be a conflict by eliminating the project area, and does that impact our development agreement? I couldn't find any reason why that would compromise the development agreement. Would you agree with that, Chapel?
Mayor and trustee Benavides, the reason that the project area was created originally, as I understand it, was that there was additional criteria that applied to applications and development of the project area that did not apply to the rest of the VC zone. And therefore, in order to leave the VC zone, basically in the part that's staying in the VC zone like it was before, then the elements of the project area that were addition to those in other areas need to remain in place. And so when it says what the changes were in the VC zone were that we just adopted all of the elements of the project area and included those in the VC zone that was remaining. Because since it was all VC zone and all project area, you didn't need the two classifications. So all you did was pull the project area requirements down into the VC zone, since it now applies to the same area.
Okay.
So that was the process, and a lot of this was discussed at the committee level, and I was in some of the discussions, but that's the purpose.
Okay, so, the development agreement is basically a contract, and so you're saying that contract has not been compromised, is that?
The purpose of this was not to compromise that contract so that we didn't get into an Albuquerque Uptown type problem.
And so I think it's understandable that the VC code may be changed next year to better suit the public. But I think the public should know that the VC code as it stands would allow the palindrome apartments that, as we see them today. Is that correct?
What is existing on that project today, other than protect architectural stuff, and somebody may have some comments, but the height of the buildings, the setbacks of the buildings, and the density of the buildings were all permitted under the VC zone as it exists today.
Okay. And not to belabor it, but I want the public to know the issue. People had an issue with 3 stories, but the issue was really about the 3 stories combined with the almost no setback. And I do worry that, that if we said 2 stories for the entire remaining sections, and if there's still a desire to have a hotel, it might not be economically feasible for a developer to put a hotel in there if it was not 3 stories. And if it's 3 stories, but it's in the interior, it's probably no more obstructive than a 2-story right at the right at 4th Street, right, with 0 setback. So I think going forward, as people ponder this, they should probably factor all that into their thinking. So let me. You didn't have to comment, but if you want.
Well, I just had a comment you talked about with almost 0 setbacks lines. Yeah. Under the current VC zone, and I was around when it was adopted, but it started back in 2003 and was amended up through 2018. It required a minimum setback of 5 feet.
Yes.
Okay, there was a variance granted when I was not here that said they could have it 7 feet back to give a little more space, but that was in fact in accordance with the VC zone requirements.
Right. I'll leave it at that. So I also want the public to understand that the village owns parcels 4, 5, and 6. So that gives the village a lot of flexibility as to what they will allow, right? I mean, if a property owner comes to us and proposes a project and that project meets the code to a T, and it comes to us for approval and either P&Z or the board deny the approval just because they don't like the project or some other reason, now that applicant has recourse, right? But that would not be the same situation here. So if a developer comes in and proposes a project that meets the code as we see it today, the VC code, I think the board still can deny what they don't want. Would you agree with that?
Mayor and Trustee Benavides, no.
Really?
I think that until you change the zoning, an owner can come in and
well, we're the owners, right?
Yeah, well, you're the owners, but you have a development agreement which gives Palindrome the right to acquire that property, and if they come in and apply for that and acquire that property, then you have that down zone problem, that vested rights problem. If the development agreement goes away, then and just the village owns it, then you can downzone it, you can do whatever you want to do with it. But at this point, we're not in that position. I don't believe, after looking at all of the documentation, as you know, I wasn't here when that was done.
Well, okay, I think that's something that I did not understand. And I think it's imperative that the board address that prior to a developer putting in an application, is what you're telling me, right?
Mayor and Trustee Benavides, if there is going to be a change in that zoning, I think the board should approve that and go through the process sooner rather than later. And how much resistance you get to doing that, and will be dependent upon the status of the development agreement and those vested rights that we have. There are certain criteria to downzone property, and the language that you found confusing and has been taken out was an attempt to set some criteria under the legal statute as to why this property could be downzoned from VC zone to core commercial zone. It's probably not real clear, so I'm not sure I disagree with taking the language out, but that was language discussed over a period of time with the committee and their counsel and that sort of thing. So it's been a complicated process.
That's all I have.
Okay, we'll go to trustee Ranovich.
I'm as surprised as trustee Benavides is. And the other thing I was going to mention is that, and this, please don't take offense, Mr. Chappell, but Mr. Chappell is an advisor. He's not a judge. And so if we decide as a board that we should be doing something else, some things have been suggested, that we have that right and opportunity as trustees. So just saying. I have other comments as well,
Okay.
Mayor, but that's
Any other
what I
comments?
wanted to throw out there.
I have lots of questions. I don't-
Okay.
I don't know how we want to go about that.
Okay. Well, why don't we just go to the point, the issue at hand first and foremost, so that we're all clear. And Shanna and Mr. Chappell, correct me if I'm wrong. The project area is governed by the contract that was signed between the village and the developer. Is that correct?
Mayor Rael, not the entire project area.
Right.
There are parcels outside of what the village owns that are in the project area.
But the project area that is under the Peladrone, if you will, contract. That contract and that project was if you will, approved by the village under the original code or the code that was in place at the time that Mr. Chappell described earlier, which is the 5-foot setback or 7-foot setback, whatever that was, 3-story building. And I want to make it clear, I'm not arguing on behalf of Peladrone in this. I'm just wanting to make sure that for the record, everyone who is listening and all of us are on the same page. This, as my understanding from listening to all the conversations at P&Z, that this, if you will, this change to create the CC zone specifically excludes the Peladrone project because it's under a contract, a binding contract, and that our ability to change the rules, if you will, on that development are governed only under whether or not Peladrone, as the other party to the contract, is willing to change those rules because of when they were, given authority to manage that site. So I just want to make sure that that I'm clear that that is still the case, and that that's how P&Z, when they, if you will, had deliberations over time on this, that was the case. And so any other parcels outside the project area are obviously available or that are impacted by this new change. We do have, if you will, because we're not bound by any contract or legal process, that we can make those changes. Am I right on that as well, Mr. Chappell?
Mayor, there are criteria for changing the zone on the other areas that are involved. And so that does not mean that someone could not, in fact, contest that zone and that the zoning that was placed on there by the village, because there are certain, the village does not have absolute discretion in terms about, it has rules as to whether or not you're restricting uses or expanding uses. And so within the context of where we are, you can probably do it, but there are some issues that could be raised by property owners that, and as Trustee Radnovich says, I'm not the judge, however, I have a good feel for what the cases say on the subject. And so you have more flexibility on the CC zone than you do on what was left in the VC zone. The same legal issues would apply, but then you have to overlay the development agreement and 4 or 5 other documents that were signed by the village related to the project area in order to make changes there. So there is a difference, a contractual one, but the zone change standard would be about the same.
Okay, all right. Okay, well, let's just now go then take this in by order of trustee. I'll go to trustee Kiefer.
Thank you, Mayor. So I have a lot of questions, Shanna, and unfortunately, I'm having problems with my Adobe, so all my notes didn't save, but I've got them written down. So I'll probably be all over the place, so my apologies. But one of the things I noticed in the core commercial zone was we were removing fireworks. Well, one of our largest businesses in the core, what would be a core commercial zone, is Gemini Fireworks. So I understand that they would be grandfathered in because we've had that discussion on other instances. However, their fear is if they ever sold the business or they ever, kids took it over, made some type of substantial change, isn't that something that we can make a permanent fireworks store conditional? So that way they don't ever potentially lose some type of grandfather standing.
Mayor Rael, trustee Kiefer, it's the purview of this body to decide what uses stay in and which ones don't. So it's absolutely your call to put fireworks store back into the code.
Okay. Yeah, I don't understand why it would have been taken out when that's one of our largest.
And trustee Kiefer, if I might just interrupt for 1 sec.
Sure.
How about we just approach this at the next meeting like we did our sign ordinance, Shanna? If you could just take notes on these changes so that we can all stay on the same script at the next meeting, and then we'll have them all listed as amendments for consideration. So I apologize, I just wanted to make sure we were organized correctly. So go ahead, trustee
No, I
Kiefer.
appreciate that, Mayor. The other thing is, I know there was a lot of discussion in planning and zoning when I kind of watched it, and maybe I didn't have to be completely engaged to because I wasn't sitting up here during those meetings. But what is the difference between the drive-through for service versus food, and what was that argument?
Mayor Rael, trustee Kiefer, the code thinks about drive-up services in a couple of different ways. A drive-up associated with an auto-oriented use, a drive-up associated with a service, and a drive-up associated with a food establishment. Drive-up, drive-through, and drive-in are all kind of synonymous, so I'm just going to use the one word. The difference is a drive-up for a bank would be considered a drive-up associated with a service. Drive-up with a McDonald's is going to be a drive-up with a food establishment. So there was a desire from the Planning and Zoning Commission that certain types of drive-throughs not be allowed in the corridor, but other drive-through facilities still be allowed.
Okay, and you mentioned autos. What would drive-through auto be?
Mayor Rael, trustee Kiefer, maybe like a car wash, something that you're not getting out of your car to go through.
Okay.
Mayor Rael, trustee Kiefer, the desire at the Planning and Zoning Commission level and what passed that commission was to remove the allowance for a drive-through with an auto-oriented use, so a car wash example, and a food establishment. So you would not see any drive-up McDonald's, Blake's, Starbucks, coffee shop, etc.
So maybe no Golden Pride?
Yes, that would also apply.
Is that an
Mayor
amendment?
and trustee Kiefer, before we go down this road and start talking about some changes like in the VC zone, there's another problem that we were trying to avoid in leaving that one just as it is. And that is that we have a number of members that could not vote if it was a vote related to palindrome. And consequently, in order to maintain a voting number of trustees, we had to leave the palindrome thing alone because of that conflict problem, because you know the rules and who's been conflicted out. So if we went right straight down the road on the VC zone, there would not be enough votes to vote on it. So we have tried to isolate it and say it doesn't affect the palindrome to avoid all of the disqualifications. And that's the reason we still want to leave it alone.
Sure. But I think this is CC zone that I'm talking.
Mayor Rael, Trustee Kiefer, yes, the changes that the P and Z Commission made related to drive-through facilities at the second hearing were only to the CC zone district.
Okay, okay.
And Trustee Kiefer, would you like that to be on a list of amendments, or are you satisfied with the conversation?
I was just kind of wanting to know the history.
Okay.
I'll kind of take that and digest it a little bit. So, talking village center zone, non-project area. I do see that it's still 3 stories. If we're talking non-village area, can that be reduced to 2?
Mayor Rael, Trustee Kiefer, as a result of this code, there is no longer a distinction. It is just one area, just VC. And so there is no way to touch the VC zone district as it's presented to you today.
Okay, so even those outlying areas, right, that are not project area, that are VC zone, those cannot be changed to limit density.
Mayor Rael, Trustee Kiefer, that's correct. Everything that was not project area is getting converted to CC. Everything that was project area will now just be VC.
Got it. Okay, okay, all right. Well, and I guess my question is kind of what you're going to, is there are other lots that aren't project area that are VC, but also if we change the Chavez's family to VC, I mean, can they put up a apartment complex?
They could, Mayor and Trustee Kiefer, they could do anything allowed in the project
zone.
area. There are, as I understand it, 2 lots that were not in the project area that are still in the VC zone. One is owned by the Chavez's, and they've come in with a development plan that's been partially approved for an office, 1-story office structure because of parking. The other is, I believe, the dance studio.
Okay, okay.
That's right.
I'm just trying to think where my thought process was going with that. Because I know that, so I guess my question is there a way to extract, and again, we're extrapolating, but I think people, when you really start talking to people, density is a huge issue. And at some point, a line has to be drawn in the sand. And yes, it may result in litigation, but sometimes litigation is of the result of protecting and defending the village and the community. You know, I know there was a lot of heartache over the previous litigation, but that's because the village lost. The village did not comply with Open Meetings Act, and a judge said so. Whether we like it or not, a judge said so. And so at what point from a core commercial or village center do we not stand by and draw the line in the sand and protect the village from the density that's taking place and make it friendly density? Not no density, because 4th Street's our commercial corridor for sure, but friendly density. And is core commercial 2 stories?
Mayor Rael, Trustee Kiefer, yes, it's limited to 2 stories.
Okay. I mean, I encourage my fellow trustees that can push on the VC zone to, you know, consider what you can do. Outdoor storage, height regulations. I didn't see a height regulation. So I saw that it has to be protected, it has to be, you know, behind a screen, all that good stuff. But I mean, how high can they go?
Mayor Rael, Trustee Kiefer, that is not currently regulated in the code. The way that I would enforce something like that is if the regulation says that your outdoor storage has to be buffered and screened by something, that any outdoor storage that is visible above that buffering and screening would be illegal. You're going to be limited on how tall you can build a buffer or a screen based on other zoning regulations.
Okay, so there is a way to enforce that.
Mayor Rael, Trustee Kiefer, yes, it's maybe just a little more roundabout than you might think, yeah.
Okay, perfect. Dark skies. I saw that these zones, and I know we changed it to the shut off of physical signs to 11 p.m. with the new sign ordinance. Is that going to apply to other outdoor lighting?
Mayor Rael, Trustee Kiefer, what the proposal says is that all lighting within the core commercial zone shall conform with the dark skies ordinance. Let me just open my zoning code and get to that section, and I think I have a regulation that can help answer your question.
Well, Shanna's going to that. Just trustees, if any of you all have some items that you want to change, I think that might be helpful in the discussion, that this is an amendment we'd like to have so that we can have further conversation, so that way we can make sure we don't miss any of the concerns you all might have. So we'll go back to Shanna.
And maybe I can ask oh, I'm sorry, go ahead.
I just found it.
Sure.
All outdoor light fixtures existing or hereafter installed and maintained upon private property within commercial or residential zones shall be turned off between 11 p.m. and sunrise. So there are existing regulations about lighting.
So that would be parking lot lighting, that would be all types of lighting in these commercial zones.
Mayor Rael, Trustee Kiefer, yes, and that's a regulation on the books today.
I'm sorry, sorry to interrupt.
You're
Did you just say that parking lot lighting could not be used within those times?
Mayor Rael, Trustee Radnovich, it says all outdoor light fixtures.
There's a certain amount of security that.
I would think so, but I also think most of our businesses would close.
But it makes it even easier for someone who's not.
Mayor Rael, Trustee Radnovich, I am allowed to issue an opinion per the code that if the applicant can demonstrate that a legitimate threat to property or public safety would exist without continuous lighting, it can remain. I think that's a little problematic, but that is in the code today.
Okay, just curious.
Well, certainly, if I might just add my 2 cents here, certainly the project area, or at least the housing, we would consider having outdoor lighting just because of safety and security,
Right.
For example.
That's right.
But, for example, outdoor lighting, to use one of our other businesses, as we have in the code, after a certain hour, they turn the lights off.
Yeah,
Right, okay.
yeah.
All right, Trustee Kiefer.
I know one of the things that has been topic of conversation, and I don't know if now would be a time for a potential amendment, but maybe adding some type of fence regulation for any new development that abuts a residential property. So that way those residential properties are somewhat protected from the noise, lights, headlights, all of that, of any type of commercial property?
Mayor Rael, Trustee Kiefer, yes, I understand the intent of that request. I would want to have a little bit of time to make sure that I craft really tight language, and so I'm a little concerned about trying to craft amendments for you on the fly, but I would be more than happy to have something ready for you on the 16th.
Sure. Okay.
Great.
Thank you. So then, this is gonna leave us with 3 commercial zones, correct? A VC, a core commercial, and a C1.
Mayor Rael, Trustee Kiefer, there's also technically the agricultural commercial zone, which is kind of a subset of a commercial zone, but the three primary commercial zones that are along 4th Street will be CC, VC, and C1. Yes. Oh, thank you. Mayor Rael, Trustee Kiefer, and the Gateway Zone District, which exists more northern up on 4th.
Okay, okay. Would it be too much, Shanna, to ask for kind of a side-by-side comparison of the three?
Mayor Rael, Trustee Kiefer, of kind of all the regulations in all of those? Mayor Rael, Trustee Kiefer, that would not be too much to ask. I can do that before the 16th.
Wow, thank you. Okay. Sorry, I told you, Mayor, I had a list.
That's all right.
I noticed in the commercial zone, there was an agricultural limitation of 10%. And I understand, you know, probably the logic behind that is this is our core commercial GRT generating area. But I guess if a business wants to come in and encompass, you know, again, I'm kind of thinking of Corrales, encompass outdoor seating, outdoor that is more agricultural based, why would we put a limit?
Mayor Rael, Trustee Kiefer, probably for the reasons you mentioned, that the zone districts need to be distinct in some way, and you want to encourage a particular type of development in one part of the village than the other. In the instance of that 10% limitation, that would be an appropriate request for a variance if someone wanted to do something other than what the code allows, i.e. that 10% metric. But my suspicion is that the intent of these commercial zones is to promote kind of the type of commercial development that you would see along an auto-oriented type corridor.
Understood. I guess my concern is we don't have a lot of private property that's going for sale, right? So it's mainly those that already own it, and the existing structures are pretty much already there. There's very vacant property. So I guess if they could remodel, redesign with a functional business with agriculture, I guess I would just remove the limit, you know, and let people be creative. Would be my thought process on that.
Mayor Rael, Trustee Kiefer, would you like me to draft an amendment for the next hearing to do that?
Yeah, and then we can see where my fellow trustees. The other concern I have is townhomes, 24 dwelling units per acre as the minimum, not even a maximum. Again, this is, you know, not talking about the project area, but there is no multifamily housing that was allowed in the VC zone. It was never in there. The development agreement somehow made it plausible. My concern is how do we ensure that we don't end up in the same situation when we're attracting and asking for such high density?
Mayor Rael, Trustee Kiefer, I'm seeing that in the VC zone district, but not the CC zone district.
Did I miss that? Okay, that makes me feel better. Because we also don't allow duplexes, but we do townhomes. Can you tell me the difference between the two?
Let me go back to my zoning code and provide you with the definitions of each of those, if there are definitions. Mayor Rael, Trustee Kiefer, the code does not define a duplex. And what I know about planning, duplex is typically 2 attached dwelling units. And it's
On
usually
one
no more than
single
2.
lot,
On
correct?
one single lot, yeah.
And then a townhome is,
Let's see, there might be a definition for that since that is in the code. There is not a definition for townhouse.
oh, wow, imagine that. So is there no definition even in the VC zone for a townhome?
Let me do a search.
I believe a townhome, you own the property below you, right? That's one distinction for a townhome versus like a condo.
Trustee Kiefer, these are not defined terms anywhere in the code.
So my question is, this kind of goes back to our build to line, right? We can't put it in there because there's no definition. So how are we putting 24 dwelling units are allowed with no definition?
Mayor Rael, Trustee Kiefer, I do think that's problematic to have a use in the code that is not defined. I would probably have to use my best judgment as kind of the zoning enforcement officer on how I interpret that term. And I would use planning best practices on how that term is defined generally, townhouse versus duplex versus single-family home, et cetera.
So can you give us options for the 16th meeting on how to define duplex and townhomes?
Mayor Rael, Trustee Kiefer, we are not, the title is not published to amend the definitions section. I'm not sure
Well, then
that we
do
can.
we just strike it from the code since there is no definition?
Mayor Rael, Trustee Kiefer, that townhouse allowance is in the VC zone district, so you cannot do that because it's in the VC zone district.
With no definition.
I think we got that point.
Well, this is why we got to where we got, Mayor.
No
I
question,
mean,
no question.
okay.
Just for clarification, Trustee Kiefer. So Shanna, the definition, if you will, under this particular item, what does that pertain to exactly on the title? Is that definitions just within the?
Mayor Rael, the title of this ordinance is specific to which portions of the code we are amending. So someone has a trigger to think, oh, I'm interested in the VC chapter, so I know that I want to show up to that hearing. It is not published that we are going to be amending the definition section.
However, if she wanted to include a definition just for the CC zone or the C1 zone, could that occur as part of this change?
I see. Mayor Rael, Trustee Kiefer, the way that we could get around that, it's going to break my little planner heart, but that's okay. We could take a definition and put it in the CC zone district instead of it being with the rest of the definitions. This is the exact issue we just cleaned up as a part of the last bill. But yes, that is theoretically something that could be done.
It's just one of those, if that's what your intent is, to try and regulate what we
Well, if
have
we're gonna say
existing.
24 units per acre, what does that look like?
But keep again in mind that that only refers to the VC zone, is that right?
Mayor Rael, Trustee Kiefer, yes, which we could not add a definition.
cannot add a
for the
definition
VC
to that.
zone.
So there's no, so just so we're clear, we're only amending or can amend only in the CC or C1 zones.
So what are we allowing the CC for townhomes?
Mayor Rael, Trustee Kiefer, the phrase townhome is not referenced in the CC zone district at all. When it talks about residential, it says that residential is prohibited except for mixed use, where residential and commercial, and then there's some metrics about how much is residential and how much is commercial, and there's a maximum dwelling unit per acre metric. So mixed use only in the CC zone district. So you have to have commercial uses and residential uses on the same property.
So Trustee Kiefer, if the intent is to not have 24 units like we had in the VC project area, or however you want to describe that, in the other codes, we could make that definition for those so that that doesn't happen again in the other.
That would be the intent, to protect those
Right.
other.
So that's why a definition in that specific area would be
Yeah.
appropriate.
Mayor Rael, Trustee Kiefer, I think maybe the best way to get at what you want in the CC zone district is to amend the dwelling units per acre metric. There's a number in there right now. I'm assuming that this number came from work out of the CAC committee. I'm not sure, this was drafted before my time, but you could lower that number if you're concerned about the density of 16 dwelling units per acre in the CC zone district.
But right now, it is lower than 24 though, right?
It's
Isn't it 20 or 16? Okay.
It's proposed to be 16 in the CC district.
Wow, okay.
And sorry, trustee Kiefer, that's a maximum number. There is no minimum in CC.
Oh, there is no minimum. Okay, so that's a maximum. All right, 16 max. Okay, I'll chew on that one. So how do, thank you. When we set minimums, right, of even 16, maximums. I guess in this case, I'm answering my own question, because what I was thinking, by setting minimums, you obliterate setback, essentially, because now you're forcing density, which could then require setback variances to meet criteria. But since we're now doing maximums, we can actually follow setback requirements.
Mayor Rael, trustee Kiefer, I don't think that particular logic would meet the variance criteria, that you would need to get a variance to do more dwellings because of an imposed setback regulation, especially if we move forward with the changes to the variance criteria, the next item on tonight's agenda. That would not pass my sniff test for a variance.
Got it. Perfect. Thank you. Got it. The other thing, and I'm pretty sure this was in core commercial, but like I said, all my notes on my actual pages are gone. I saw parking requirements being removed. Is that in the core commercial, or was that in the VC zone?
Mayor Rael and trustee Kiefer, that's in the VC zone district, and it says that parking requirements are negotiated in the site plan instead of being set directly.
Got it. Okay, so that was VC. Okay, and then that's it.
All right.
Thank you.
Okay, well, I think it's really important then, Shanna, if we, in the next couple of days or so, try and get those amendments lined up so that we can have the conversation, much like we did with the sign ordinance. So I'm going to go now to trustee Ratnovich. Do you have any items?
Yes, I do, Mayor.
Okay, very good, very good. All right, go ahead, trustee Ratnovich.
Also, I'd like to add that I would like to see any amendments prior, as I'm guessing the whole, the whole group would.
Mayor Rael, if I might ask Danielle when she intends to publish the packet for the meeting on the 16th, because that's generally that table of amendments.
Yep.
Mayor and trustees, let me take a look at the calendar. Typically, I like to try to get that packet out either the Wednesday or Thursday before the trustee meeting, so that would be, I can't find my calendar. The 11th.
Mayor Rael, okay, thank you, Danielle, that's helpful. That's plenty of time for me to put together amendments and for it to be in the full packet that goes out to all trustee members.
Okay, thank you. I had a couple things. One, I want to say something before I comment on it. I think we want a village center and a commercial core zone that is very pedestrian, vehicular limiting, including parking, on-street parking, to slow people down as they're driving through the area, much like the newest part of 4th Street. And so making it less auto-centric is really important, I think. Because if you think about towns like center of Santa Fe, or the center of Taos, or even, for that matter, the center of Las Cruces, you don't see Chick-fil-A's and McDonald's and so forth. So I would try to limit drive-throughs, period, with no, I don't think there's a difference between a drive-through from this perspective, from a town design perspective, between a bank or a McDonald's myself. So that's one thing I wanted to comment on.
Mayor Rael, Trustee Radnovich, would you like me to draft an amendment that would take all the
That-
drive-through uses out of the core
I'd be
commercial zone?
curious what other people on the board think about that. Trustees?
And I would say that curiosity will get solved on the 16th when the amendment comes up, for sure.
Just curious.
Yeah, but I understand and I appreciate it. Here's the one thing that's interesting about drive-throughs that's important for us to also think about. Think about what's happening now with retail. They're not quite drive-throughs, but you drive and you park, and people come and get your food or get your groceries. And so it's not
That's different.
necessarily. It is. Yet it's somewhat the same principle, right? The idea is not to get out of your car and to, in this case, they're just parked in a particular area. So I'm not arguing against your point. I think your point's an interesting one to consider. I'm just saying is that we don't even have that yet in our code in terms of what you regulate.
The best villages and towns
Sure.
are ones that don't have an auto-centric center.
Yeah.
I would make two comments about that, not to derail you.
Yeah.
Because I think you might be fine with what you're saying. But during the time of COVID, drive-throughs became very important. So that would be one point. The other point is and so I think, I don't think this zone will cover the Lottaburger on El Pueblo, right? But if they expand, they're probably going to want to do a drive-through, and nobody wants you to touch their Lottaburgers. Keep that in mind.
Good point. Another comment I had was, and this is probably a legal question, Bill. On the second line, it says cultivation of cannabis and hemp anywhere within the property. I think state law allows cannabis to be grown on your personal property, if it's a townhouse or whatever.
Yeah, we're not.
How can we limit it here when state law allows it?
Mayor and Trustee Radnovich, that's a good question because there's still a lot of discussion about that. And you have to be licensed as a private grower and things like that. And I don't know how that's going to come out. That's one of those areas that if the village wants to say, we don't want it there,
I wasn't talking
I'm
about
not-
commercial. I was
Yeah, I'm
talking
just-
about homeowner or condo owners or.
I'm perfectly willing to have that in there, and if somebody wants to contest it, we can see where it comes out.
Trustee Radnovich, the use is cannabis establishment. If you go to the definition of that, which there is one, that refers back to the state code. So this is specifically talking about commercial production.
I
This does
see.
not touch personal production at all.
Okay.
Well, except that if you put residences in the commercial zone, then the residents do have a right under state law to grow, I don't know how many plants. But maybe it's like.
It's a number.
It's a number, yeah. Not for commercial use, but for their own personal use. I think that right already exists, right?
Mayor Rael, Trustee Benavides, that's right. People do have the right per state law to grow cannabis for personal consumption. This use is only about commercial production. So where it would become illegal is if there is, say, a townhouse in the CC zone district where someone is cultivating cannabis and then is also selling it. That's what this is saying would not be allowed.
Well, if you're using the word production, growing something is production, right?
True.
But it doesn't mean, then you use the word sale, which obviously is not something we want them doing, but they are producing a product for their own selves.
Mayor Rael, Trustee Benavides, I should have used the word cultivation. That's the word that the code uses. And cannabis cultivation also refers to the state definition for cannabis cultivation, which is a commercial definition.
Okay.
The third one is one that Trustee Kiefer brought up, which was the 4th of July, the firework stands. Yeah. Hold on.
Trustee Radnovich, are you wanting an amendment on the cannabis line item?
No, if it's commercial we're talking about, I assumed mixed use for that one, and so I was thinking commercial below, residential above, and restricting people that might be in the residential portion of a mixed use facility. So no, I'm good with that.
I thought maybe you were referring to the 10% issue that
You must grow it.
that Trustee Kiefer had.
Are you talking about the strength, Mayor?
All right.
One more. How did you come up with the 16-foot limit on a residential lot in Exhibit A?
Mayor Rael, trustee, that was written before I was here, so I cannot speak to the origin of that. I'm sorry.
It seems narrow, but maybe not. I haven't lived in apartments for a long time, but that seems like a narrow space, so I was just questioning that. And I know architects have kind of almost cookie cutter kind of configurations for apartments, and I just don't know how that 16-foot fits into that.
Mayor Rael, trustee, to be clear, that's about a residential lot, so that's not about a unit. That's talking about if someone is going, I'm not sure why there are platting regulations in the zoning code, but this appears to be
So a residential lot's 16 feet wide?
minimum 16 feet wide,
That seems
minimum
very
100.
narrow to me.
I would agree.
I would question that one, just saying, Mayor.
All right.
And trustees. Another one that I was concerned about was on page 15, bless you, whoever that was, covered patios. It said covered patios must not extend beyond the footprint of the first floor, except where a building abuts 4th Street. Wouldn't we, covered patios make for a much more comfortable environment in summertime for residences and even for businesses. So I wondered about that one, because we would probably, in my mind, we would want to encourage shaded outdoor space as opposed to discouraging it.
Trustee Radnovich, I am just checking. Yeah, that seems like kind of a funky regulation to me. Is that something you'd like me to take a look at?
If you could, that would be great. I think it just makes, we don't use our outdoor spaces enough that way to provide comfortable spaces for people. I was going to say the same thing about, on the same page, excuse me, H4, shade provided by landscaping. Shade shall be provided for a minimum of 50% of the pedestrian or bicycle path. That seems very low to me too, when you consider the city of Albuquerque, as an example, has a shade tree ordinance that requires a tree every 30 feet. So I think that should, boy, I'd make the minimum higher than that.
Do you have a number, trustee, that you would consider to be?
Probably 75%, which is what the city of Albuquerque ordinance has for plant coverage.
Okay. Why don't we include an amendment for that, and then we'll see if there's any concerns about the number.
Noted. Thank you.
And then under I-2, under parkland, it says 20% shade, and people congregate under shade in New Mexico, and so I think it's really important that we have at least 50% in a park environment. That seems crucial to me. I mean, unless the park is for, some kind of sport. Basketball. On page 16, and I have quite a few too, Mayor. I'm sorry. Apologies to all the trustees and Mayor. The one on the very first two lines struck my attention. Exterior walls that face 4th Street or Osuna Road must have glazing with clear glass for a minimum of 30% of the area on the facade. People have asked for, a grocery store in Los Ranchos for quite some time. And grocery stores, as you may know, they don't like to have glass fronts because people break in that way. And so that's why you never see a Smith's or other grocery stores with glazing on the front of them, because it's a theft issue. So I wondered if we could make an exception for grocery stores, since grocery stores are something that the people of Los Ranchos have asked for, and so that we don't put ourselves in a position that limits the way a grocery store works from that perspective.
Trustee Ranovich, I can definitely draft that. That regulation also exists in the C1 zone district and the VC zone district, so we could make a carve out just in CC for now, if you'd like.
I think that would be good. I mean, we're trying to encourage stores like that, and so.
Okay.
This one's more of a question. I think the term, I've not heard of the term in architectural or planning code, modulation, which is on line 14 of page 16. And I think that word needs probably a definition. I've heard articulation.
Articulation is also what I'm familiar with.
Okay. So modulation means articulation?
Yeah, would you like me to draft an amendment to change that to articulation?
That's
I would also
what most
prefer that.
architects would go by.
Oh, I thought we were talking about the number of amendments tonight, that we were going to be like modulating the number of amendments. Just kidding.
I had another one that's aesthetic. It's line 25 on page 16. And I'll try to make these as brief as I can, Mayor.
Go ahead.
Metal wall panels. There's a lot of really nice looking buildings that are using rusted metal wall panels. The building that's right next to Plants of the Southwest in the village, which is mostly therapists, I think, has a rusted front, and they're really nice looking. So I wondered about limiting materials. Aluminum siding, I totally get. But metal wall panels may be a different case. And we've even used metal wall panels on architecture to kind of mimic the way northern New Mexico farm-style buildings look, only not on the roof, but on the sides of buildings. And I think it's a nice look, and it's very warm. So I questioned the wall panel comment.
I can draft an amendment to remove metal wall panels from that list.
Thank you. This is on page 17, and it's the second one under residential. Especially since this is in the core zone. It says that for residential use, there would be one space per bedroom allowed. If someone had a 4-bedroom townhouse, that could make the entire front yard parking. And so I wondered if we wanted to limit it in some way, so that if someone decided to build a 4-bedroom townhouse or 5-bedroom townhouse, that they wouldn't get 5 parking spaces, and make it a little less pedestrian oriented.
Trustee Ranovich, I think there's 2 ways to do that. You could either implement a parking maximum, or I think codes will often nuance this out a little bit, that it's 1 for every 1 bedroom, but 2 to 5 bedrooms, it's 2 spaces total, or something like that.
We might want to have some kind of limit on that.
Okay, I'm hearing a parking maximum just for residential?
Yeah, yep. Oh, and this is small, but it's because I'm a landscape proponent. Under sandwich boards on line 24 of that same page, I think we should add that they can't, and I've seen this happen in the village, they can't put sandwich boards in our landscaping. I've seen them put over the grasses on 4th Street. So,
Trustee Radnovich, the sign code today prohibits any signage in the public right-of-way, so that is
Oh.
already illegal.
oh, that's great, thank you. Sorry, I missed that. I think that is it, Mayor.
All right, very good. Trustee
Thank you for
Renna.
the time.
You're welcome, thank you. Trustee Renna, I know you have one. Go ahead, trustee.
I don't have much to share this evening. I've already shared my written comments with Shana several weeks ago, and she did get back to me with her responses. And so I've seen several of those already included in the packet. But again, I think excuse me, I think that what we need to have open to us to consider are the comments that were made, the suggestions made from P&Z at their last meeting. And, you know, to be able to have some discussion about those on the 16th. But I have nothing more to add. She's responded to the comments that I did have.
Okay. Trustee Benavides, did we get through your list?
Yes.
Very good. One, just comment, the speakers that talked about removing their properties from the map, we had that conversation. Do we want to include those as part of our amendments to consider? And then that way, Shanna, you can put those as well on the table for conversation.
Mayor Rael, you're asking me to prepare those for the 16th?
Yes.
Yeah, that'll give me some time to work with them on
Okay.
what their exact parcel numbers are, which is pretty important, so I would appreciate that.
Absolutely.
So
Shanna,
that confuses me because, our next agenda item is the map.
Right.
And I can make an amendment.
I'm sorry, you're right. It'll be in on the other document, right?
Mayor Rael, Trustee Benavides, as long as you have the exact parcel numbers, we can do that.
The property description, is that what you're asking?
The property description, or ideally the UPC codes, there's a couple ways to refer to the properties.
Okay. It appears like we do have that information.
Yeah, Mr. Chavez seems to have them back there, so you might, before you leave, get a
I also have them if we need to state them for the record.
Okay, but that's the other document, right? Shanna, that's the other ordinance that we're talking about?
Mayor Rael, yes, that'll be the next item.
All right, so on this particular ordinance then, number 306, we have now finished putting together, and I think the plan on the 16th is to entertain those amendments that have been presented tonight, or those amendments that were raised. And just again, for the public's discussion, we will then now move to approve the advertisement of this ordinance, and would encourage anyone who's listening, and will obviously include that information in as we publish for information for the community, to be here for the next meeting on the 16th to further discuss this ordinance. So with that, we have a motion to, do we have a motion on the table? Yes. We did. All right, any other further discussion on this ordinance? Seeing none? Oh,
Don't look at it.
No, I have
Don't
not.
look at it.
all those in favor of the ordinances for advertising signify by saying aye.
Aye.
All opposed, same sign. Motion carries.
Mayor, I'm gonna get a mirror the next time I come to the meeting.
I'm going to have one on this end. All right, we'll move now to ordinance number 307, an ordinance ZMA-25-01, requested by the Village of Los Ranchos de Albuquerque to update the official zoning map of the Village of Los Ranchos by amending the existing VC Village Center zoning designation of certain parcels to the CC Core Commercial, approved to publish and advertise. Ms. Shanna, to please describe the ordinance, please.
Mayor Rael, trustees, this again is just the follow-up zone map amendment action that will create the core commercial, I'm trying to share my map again. This will create the core commercial designation on the properties depicted in purple. Those properties will be subject to the new commercial code that you just heard about, and that you will make amendments to at your next hearing.
Okay. Madam Clerk, do we have anyone signed up on this particular ordinance?
Yes, Mayor, we do. The first individual is Mr. Ron Chavez. If you would, please approach the podium, state your name and address for the record, and you have 2 minutes. One second.
Hold on, Mr. Chavez, I think the mic's not on.
Can you hear me?
Now we
There we go, okay.
Totally against being included in that Core 1, C1 zone map amendment. Don't want nothing to do with it. We
Okay,
want our C1 zoning back that was granted to us by the founders of this community. And that's about where I stand on it. And she had a lot of good things to say about the VC and the Core 1 zoning. It belongs on Forest Street. It never did belong on Chavez Avenue. It never did. So that's one of my points. And there's another point that map that you guys have been looking at is wrong. And I mentioned that map to the committee, which I was a part of, but they didn't pay attention. So you may want to take a closer look at those properties that I'm talking about. One of them has been subdivided and granted variances for residents during all this process. And those are lot 41F2, 41F1A, 41F1B, 1A, 1B, and 2. But the ones that were subdivided are the 41F2, 41F1A, 41F1B. If you look at that, it's still 1 acre on the map. It's been subdivided into 3 lots for a long time. So you guys have been looking at the wrong map as far as our concern.
you got those, Miss?
Mayor Rael, no, I do not. Can you please read the numbers that you're reading are the properties that you
The
wish
lot-
to
the
not
lot
be
numbers,
included?
yeah, right.
Can you read those again a little slower for me? And I
I've
will,
got the legals here to give to you here in a while.
okay.
Perfect.
So we want to be put back in C1.
Okay.
Okay, thank you.
Thank you, Mr. Chavez. Next, we have Mr. Stephen Chavez.
Stephen Chavez, 432 Chavez Road. I know you guys have timelines for publishing, and thank you for considering amending the map and, looking to put it back to VC and then us, putting in a application to rezone it. I'm not sure how it works, or if you guys could introduce an ordinance for another zoning map amendment to just change us to C1 for those properties or those lots. And then also just kind of looking into what type of residential is allowed on C1. I know, like I was saying before, a lot of these zones that you guys do have, it's very hard. Duplexes are not allowed at all. So it'd be nice to kind of work with you guys. I'm more than happy to help draft an ordinance for the zone map amendment to kind of look at what we could add in there to see what we can do. And I'm more than happy to sit down with whoever. I don't know if you guys introduce the bills individually to be introduced and then, further on. And I believe that would keep you out of Q and J, since this would be a whole new map amendment that wasn't passed through planning and zoning for the 2 new trustees that will be coming on in the future. So those are my only thoughts. Thank you, guys.
Thank you. Let me ask you a question, and we don't typically ask members of the public when they're coming up to speak on these issues, but I do have one question. This process has been going on for some time. Were you aware of the changes and of the maps that were being developed through the course of this discussions?
I know in 2018 it was changed to VC, from C1 to VC, and that was kind of like a pencil in to the zonings.
But just within the last
In the
year?
last one, of course, there was a committee. If you're one member of that committee and you have something different that committee wants, and they introduce something, your word isn't very powerful when that whole committee is kind of going against the one person that's, speaking in terms of keeping it a certain zone. So yes, I was aware of them. I know you guys do have planning and zoning meetings for people to voice their concerns. But I do believe if someone introduces an ordinance for a zone map amendment and changes these properties back to C1 with maybe some amendments to the conditional uses. That'd be kind of where I stand on it, and would be more than happy to sit down with
Okay,
whoever may be interested in doing that.
thank you very much.
Thank you. Mr. Randy Gallegos, I believe he left. So with that, Mayor and trustees, that concludes public comment on this item of business.
Okay, we now need a motion to approve publication of ordinance 307.
Can we do that with an amendment, or do we do the amendment afterwards?
We can do the amendment afterwards.
Okay, go ahead, Frank. Do the initial one if you want.
I'll make a motion to approve ordinance number 307.
Do we have a second?
I'll second it.
It's been seconded? Okay, now we're on the actual ordinance for publication. And I suspect we'll treat this as we did the previous ordinance, which is if there are amendments that we would like to have included, then we should have those presented. So I'll go to Trustee Benavides.
Yes, I mean, I can make an amendment. I think Jennifer can make the same amendment. I always forget the process because we do it differently now with Chapel. But so if we make an amendment, do we all vote on the amendment? And then is that what happens?
Mayor and Trustee Benavides, typically you would make a motion to amend the
Yes.
ordinance if the person who made the ordinance concurs with the amendment and the person who seconded it concurs with the amendment, then it becomes a part of the motion. If you don't get the concurrence of the person who made it and the person who seconded it, then you make the motion, it is seconded and voted on, and then you move to the main motion.
But do we still have to vote on the, let's say the person that made the motion and the person that seconded the motion are agreeable, do we still have to vote on the original ordinance without the amendment? And then we do the amendment?
No, if they
Do it all
agree.
at one time?
Yeah, if they agree, it becomes a part of the motion, and then you vote on the motion one time that has that amendment to it.
All right, so I'd like to make an amendment to the map on page 57. And I would like this amendment to redraw the yellow line, which will now move some residential properties back into the VC zone. And the residential properties that I just, and somebody, please raise your hand if I missed something, Ron, if you notice. Lot 41F2, Lot 41F1-A, Lot 41F1-B.
Trustee Benavides, I'm sorry, can you start over and go just a little slower for
Oh,
me?
of course, I'm happy to do that. Lot 41F2, Lot 41F1-A, Lot 41F1-B, and Lot 1-A. Is that Susie?
Yeah. So,
Okay. Lot 1-B and Lot 2. And these properties comprise the addresses of 432 Chavis and 502 Chavis.
Yeah.
Oh,
there's San Diego too. So don't worry about that.
oh, don't worry about those, okay. Okay, so just the lots, I think, would suffice. So we want to redraw the yellow lines to leave them out of the core commercial zone, so they will revert back to VC. This is step one in the process. The next step would be for somebody to come in and make an application for C1. But anyway, so we asked whoever made the motion if they accept that in the second.
So my understanding then is that we're reverting back these properties to the VC zone?
Yes, I mean, ideally, we could do it C1 right now, but
Sure.
apparently we
Okay.
can't do that today.
But, and then the second part of that would be a new application to move it to C1.
Yes,
Okay, I'd agree.
okay, and you second it, right?
I seconded it. I
Okay.
agree too.
All right.
All right. So just from a practical standpoint, let me just, I don't necessarily disagree with the intent of the amendment. And obviously, the four of you have the vote. But what does concern me a bit here is that there may be other property owners who did not recognize that this was about amending the map, because it was just advertised as for public, for publication only. And so my original comment was, I thought we were going to do what we did with the previous ordinance, which is we would ask Shanna to prepare an amendment for the 16th to remove those properties. And that way, if other folks did come on the 16th, they would obviously have the same opportunity for us to do the same. I get your interest in trying to do that tonight, but I just want to make sure that we're clear, because right now, we've just it says published for advertisement. And so I just want to make sure we're not, and I don't know if that'll become an illegal issue for us or not, but I just wanted to make sure we're clear on that.
So what, are you asking for a legal opinion right now, or?
No, I'm just asking for you all's perspective of that is, the way we handled the others was to put them all for the 16th meeting, to vote on them, and so that way, it's up for final adoption, and for final adoption, you normally make all those changes, because we just put it on the, advertise it just for publication. It's just a very different dynamic, but it really is up to the four of you. If you all want to amend it now, that's fine, but.
And Mayor, and I appreciate your comments. I guess my question would be, if anyone comes up on the 16th, we could still make an amendment to do the same with their properties as well,
Sure.
correct?
We could.
Okay.
We could, yeah. But having said that, there's an amendment on the table to exclude the properties as outlined by trustee Benavides. And do we have a second? Second by
Yes.
George?
No, I seconded.
They agreed to allow it.
Yeah.
But I
Okay.
guess.
Did I miss something?
Yeah,
we need a
no.
second?
Let me go back to the Robert's Rules of Order. We have a motion on the table for approval of advertising the ordinance. We have an amendment to the ordinance, in the body of the ordinance, to change, to exclude some properties from the map. That's a separate, you don't need concurrence from the original, if you will, motion, because we haven't voted on that. So we're on the amendment. All those in favor of the amendment signify by saying aye.
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 All opposed, same sign. So now that amendment is now going to be incorporated into the ordinance when we publish it, when we present it on the 16th. Got it. Okay. Any other changes in this ordinance?
I have just a comment,
ahead.
Mayor.
Yeah.
And this,
Trustee?
this may be for future reference, and this sounds counterproductive, I believe. But the old bank building on the northeast corner of Osuna and 4th Street, I worked on that project years and years ago. And it struck me as I was looking at this map and thinking about it, that that property is about a story below grade. And it made me wonder, if I were a developer, as an example, and saw that the commercial area was really booming, wanted to develop something, could we make that particular parcel three-story from its current elevation, because that bottom story could be parking, a platform building in effect. And it would be the same height as the building across the street's second story. And if we didn't, they're going to be importing a lot of dirt to get that up to the grade of all the other parcels. Now, this may be a little too detailed, and you know I like detail, Mayor. Apologies for that.
Yeah, I don't want to take that one on.
But that one property is very different than all the others in the Village Center zone. So I don't know if there's a way to.
You make a good point, but yeah.
Go ahead, Shannon.
Mayor Rael, Trustee Radnovich, as a part of this action, which is changing the zoning designations, I can't think of a way to do that. We could consider if there's a creative zoning rule we could put into the CC zone district about properties that are below grade. I would welcome your input on what that would read, and we could have that ready for the next meeting.
Okay, I'll provide some input. I guess I can't send it to all the other trustees, but I can send it to you. And you can get it there. It just struck me that.
Sure.
Yeah, and Mayor, I'm actually trying to be trustee for all of the 24-hour days that we have from now until the end of this year. So, you know, hopefully I can.
Well, I chuckle at your, I mean, I appreciate your thoughts. I chuckle at the interest of putting a parking structure, since not just like 7 minutes ago, you talked about, we got to discourage automobiles and have everybody have it more of a walkable community. And now we're putting structures to park them.
Underneath the pedestrian zone.
I appreciate that.
Underneath the pedestrian
I hear
zone.
you. I hear you. All right, well, we'll come back and look and see if we can do something to that, but I do appreciate your.
I'm a complicated person.
All right, any other discussions on this particular ordinance? If not, go to the vote. All those in favor of publishing ordinance 307 signify by saying aye.
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 All opposed, same sign. Motion passes. Now we're going to ordinance number 308, an ordinance TA 25-03, requested by the Village of Los Ranchos de Albuquerque to amend the text of 9.2.2 Planning and Zoning Commission, 9.2.4 General Regulations, 9.2.7 A-1 Agricultural/Residential Zone, 9.2.25 Application and Approval Process, and 9.2.27 Conservation Development Standards Permits, Approval to Publish and Advertise. Ms. Shannon to explain.
Mayor Rael, trustees, this is a request that was born out of a resolution from Trustee Kiefer to look at the review and approval process at the village. So this does two things. One, it proposes to remove the administrative conditional use. Right now, I do have the authority to approve conditional uses if they make it through what's called a 15-day adverse comment period. So someone applies, we send out notice to the neighbors. If no one complains within 15 days, I can approve it. There was a desire that all conditional uses should always go before a public hearing, i.e. the Planning and Zoning Commission. And so the first change in this bill proposes to make that change. The other change associated with the conditional use process proposes to add some language to say that it's the applicant that has to justify their conditional use. This was a minor addition by me. I think sometimes folks come in and think that it's planning staff's job to justify their request, and it's not. It's my job to kind of fact check their justification. So there's a little addition about the applicant providing justification. And then lastly, over to variances, there's a proposal to remove variance criteria number 5. This would leave variance criterias 1 through 4 in place, which are much more standard variance criteria related to the size and the shape of a lot, that if for some reason you ended up with a lot that is so funky that you cannot build on it, that's when it's appropriate to get a variance. Variance criteria number 5 in the village is a unique one. I've never seen one quite like it before, which says that other relevant factors exist that, when taken into account, indicate that the granting of the variance is substantially justifiable. That is a very open door. It doesn't relate to the physical characteristic of the lot in any way. It goes on to talk about the interests of the property owner. It's just very non-standard variance criteria. And so the third change in this bill will delete criteria number 5, leaving just criteria 1 through 4. I'll stand for any questions.
Okay, do we have anybody signed up to speak on this?
Mayor and trustees, we do not.
Okay. We need a motion to approve the publication of ordinance 308.
Motion to approve the publication of ordinance number 308.
We have a motion. Do we have a second?
I'll second it.
Motion's been moved in second. All right, we go to discussion. Any discussion from any of the trustees? All right, trustee Ratnovich, you get the first bite at the apple today.
Oh, boy. In a few places in the rewrite, you noted, and maybe this isn't in the rewrite actually, but you noted that the regulatory burden on applicants is going to be greater. Could you explicate that a little bit? Because that worried me a little bit, because that's money. And
Mayor Rael, Trustee Radnovich, let's start with conditional uses. Today, there is a path for someone to have a conditional use approved in 15 days flat. If this goes into effect, there is a mandatory public hearing, which has about a 6-week lead time at least, and that's assuming that you only have one public hearing, that there's not a deferral, et cetera. I would consider that a burden on an applicant. In terms of the variance changes, I do think removing variance criteria number 5 will make it harder to get a variance in the village. And I also think that that is a burden to an applicant, that they will really have to justify why their lot is so abnormal or prohibits development. It can't be for these other reasons, such as, I want my building to be this tall because I find joy in vaulted ceilings. That could technically be a criteria number 5 justification right now. So those are kind of my 2 explanations.
okay, that makes sense.
Okay,
Okay, that was my only question. I don't have any others.
all right. Trustee Brown? Trustee Benavides?
I have none.
Trustee Kiefer?
I have one. And thank you, Shanna, for all your work on doing this. I remember you and I talked about it. You brought it before the board. We sent it back to planning and zoning because we were all in favor of this. And this is planning and zoning's recommendation to us. My only concern is we're eliminating the word injurious and we're replacing it with create material adverse impacts, which I completely understand because we want to get rid of the subjectiveness. However, my concern in injurious, right, and I did some definitions on why injurious makes more sense, is injurious as a neighbor, right? Could be loud noise, could be lights, it could be density, it could be cars, it could be traffic, and it's what we have sworn to protect and, health, safety, welfare of the residents. A neighbor could say this is injurious. When we change it to create material adverse impacts, I mean, what would a neighbor have to do on a private easement? Do a traffic count to materially show that there's a traffic implication of this new development? Or, light testing with, I think we can leave the create material adverse impacts in a commercial type zone because that is more of where we expect to see the urbanization. But I think with as many private easements as we have in the village, as many private driveways we have, I think leaving the word injurious is more important because it protects the neighbors without them having to do some type of costly and or impossible ways to justify material adverse impacts. And that would be what I bring to my colleagues in looking at this, is reverting it back to injurious and allowing residents to be able to have their opinions.
Mayor Rael, Trustee Kiefer, this was the one proposed change that came from your Planning and Zoning Commission. This was not proposed by me. This was by P&Z. And the conversation surrounding this was that they were really struggling to figure out what injurious was and how to define that and how to use that. However, the phrase material adverse impacts does occur elsewhere in the code. It's part of the conditional use criteria. The conditional use criteria does use the phrase material adverse impacts. It does not use injurious. And they felt like that was easier to justify and understand. So that was the intent behind the change. It is definitely your purview to include that or not.
So let me make sure we're clear. So the substantial impact, you're okay with that being in the commercial, if you will, side of the or zone code, but when it comes to residential lots, you want to use the word injurious.
I mean, I would prefer injurious remaining the same across all, but I do think that it is more feasible to do, to prove material adverse impacts in a commercial type zone than you're going to in a residential zone.
So would,
Trustee
so, you know, so if we were to add wording that it would be injurious to the health and safety
Health, safety, and welfare.
and welfare of individuals, that I think clarifies it a bit. And enables, you know, Shanna and staff to be able to assess what the level of injury is here. I mean, I think we need to have further definition of it.
So let me ask this question, maybe, Bill, you may be as puzzled as I am. What is the actual definition of injurious in this context, as we best can tell? Or maybe Shanna, or maybe even Trustee Kiefer, what is actually?
I have ChatGPT.
That's what I thought.
Okay.
That's injury.
Yeah,
Injurious to adjacent neighbors versus create material adverse impact is what I asked ChatGPT.
Okay.
The focus protects immediate neighbors most directly affected, which is injurious to adjacent neighbors, versus the evaluates the broader community-wide impacts. Harm type captures subtle qualitative harms, noise, privacy, light spillover, neighborhood character, versus requires significant, measurable, quantifiable impacts. There's a lower threshold on the injurious because it allows protective intervention versus higher evidentiary threshold. It supports neighbor testimony and lived experience versus requires studies, data favoring well-resourced applicants.
that's fair.
I mean, it keeps kind of going, but that's kind of how it looks at injurious versus material.
Wow.
Billy, you're looking very confused.
Bill, what's your perspective on this? Defending it in court.
Mayor, my take on it is that whether you call it material adverse impact or injurious, or maybe you should say materially injurious, the discretion is going to be applied in every case, and you're going to come out with the same decision, whatever those words are that you use, because both could qualify. And so perhaps you should have material adverse impact or be materially injurious, you know, and so that it's a material kind of thing. What you're trying to get away from is somebody says, yeah, well, I heard their dog bark 6 times last month, and that's injurious to my sleep. And you know, everybody has to make a level determination as to whether or not it's material before. You know, legally, contracts are not breached unless it's material, all those kind of things. So I think from the discussion I heard at the P&Z was just trying to do something that makes it material and not just somebody's attitude or opinion.
But at the same time, Mr. Chapel, you just said they're synonyms to one another. So, but you also said they're synonyms to one another, so.
No, I didn't use that word. I said you
Well, you
could
didn't say
come out to
synonym,
the
but
same
come out.
place, yeah.
Right, come out, so they're equivalent in discretion.
When it comes to discretion, I think the board is going to make a decision the same way whether the words material adverse impact or injurious is used, is all I'm saying. I don't think the words are distinct enough to have a different outcome when the board is looking at it. So I don't think it makes a lot of difference, but you may material adverse effect or injurious. You could use both of them.
So trustee Kiefer, would you like to have Shanna put this as an amendment for adoption of the ordinance when it comes in December, the 16th, or would you like to do that tonight?
Well, I guess, is it already an amendment? Is it already an amendment when it hasn't been adopted and is still a recommendation? Because injurious is already as is, right? So the only thing that would be changing as far as definition is leaving it as is.
Right.
Mayor Rael, trustee Kiefer, I can speak to my experience working with other planning commissions and boards. When a planning commission has made a recommendation to that body, that recommendation has been incorporated into the text that that body sees, and so it would need an amendment to remove the recommendation.
Okay. I mean, I guess I made the original motion. I'd like to restate my motion and leave the original language as such and remove create material adverse impacts.
So why don't we do it more practical, since we have a motion for approval of the ordinance. You are going to make an amendment to remove the material.
To remove create material adverse impacts and leave the wording be injurious.
Do we have a second on that amendment?
I'll second the amendment.
Okay, it's been moved in second. Any other conversation? All those in favor of the amendment as presented signify by saying aye.
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 All opposed? Okay, amendment's been incorporated into the body of the ordinance. Any other changes to the ordinance? Seeing none, all those in favor of the ordinance as for publication signify by saying aye.
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 Opposed, same sign. All right, the motion passes. There are no other action items on our agenda except adjournment.
A motion to adjourn.
Do we have a second?
I'll second it.
All those in favor of adjournment signify by saying aye.
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 All opposed, same sign. We are adjourned at approximately 8:22.
Nice.
All right, everybody. It's plenty.
The 16th is going to be a long one.
Oh, my God, yeah. Well, the interesting part about, I'm assuming we're stopped.